I've come across many cases where children have been left in a very damaging environment and have been caused harm by that. And of course, I have a number of cases that I can't talk about, which I'm dealing with, where you have adults who have suffered as children tremendously as a result of being in care and the care not being appropriate, or through failure of early intervention.
With the recent revelation that all but one children and young people-centric greenfields over the last 5 years were already in the care of the Children's Minister, and repeated criticism over the lack of therapeutic facilities for struggling young people, there have been calls to improve care proceedings and children's services as a whole. We asked local lawyer Darry Robinson to share his view on the issue. To start with, Darry, would you be able to tell us about your background and your experience in children's law?
I've been a lawyer for, I believe, over 20 years now. I practiced in the UK before coming to Jersey, and I've been a Jersey advocate for over 10 years. When I came to Jersey, I started working on children's cases at that point in time. It was an interesting time because the children's law, the 2002 law, came into force just after I'd come back to Jersey. And so I think that came into force about the beginning of August 2005. Now, I started working on children's cases because the firm I was with, there was nobody else who really wanted to deal with those cases or really had the experience to do so. And the thing that struck me at that point in time was that there was a very, if you like, a very casual approach to the court process. So when interim care orders were being dealt with by the court, previously called or previously known as interim fit persons orders, it was often the case that those orders would be applied for and granted without, for example, the parents being heard, without the lawyers for the parents attending, and without the child having any representation whatsoever. And of course, by that I mean the representation of the guardian who assists children in care proceedings. That, of course, that role came in on the back of the children's law. So, for my own part, I wanted to be involved in these cases because I found them stimulating, and I felt that the human rights implications that flow with a children's case was of particular interest to me. I recall at one point briefing an advocate who was dealing with a case when I was working at that time, and I prepared her submissions for her, and she went before the Royal Court. And in those submissions, I'd referred to a human rights case. I believe it was the KT in Finland case, which is a very important case. And as my submissions were being rehearsed before the court by the advocate, it became clear to me that she hadn't really grasped the significance of the case and didn't really understand the way in which the human rights law was underpinning matters, childcare cases that were before the court. And I think at that point I decided I must qualify in this jurisdiction. And so I did. And then after working in private practice, I joined the Law Officers Department for a time. I worked with them, I think, for about possibly 7.5 years. During that time, I spent some time in the children's team, where I was representing the interests of the children's service. And again, I realised that there were multiple breaches of children's human rights in the process that was being adopted by the children's service. And in addition to that, I was at a loss to understand why claims weren't being brought on behalf of children for injury caused to them as a result of their experiences in care. And that, I suppose, flows into my most recent appointment, which is with Benny and Sivray. And I've been with Benny and Sivray for, well, it must be coming on to 3.5 years now. And it was a perfect fit for me because, of course, Nina Benny is an excellent childcare lawyer, and Philip Sivray is an outstanding litigator. So we work well together. And it allowed me to then develop the practice which I've moved forward with in Benny and Sivray, which is, of course, dealing with human rights breaches to children, and also dealing with claims that stem from children who've been abused or mistreated in care.
You were discussing how when you started looking into children cases, you identified breaches and issues in the process. So what is the process like now? Could you explain what a child would go through when, for example, a care order has to be made in their respect?
The experience for a child who is committed to the care of the Minister for Children and Education, in fact, of course, committed in reality to the care of the Children's Service, it must be a very hard experience. And I'd ask you to just consider, if you will, for a moment, a child of perhaps 7, 8, 9 years of age who, without any notice at all, is taken from their family, put into the car of a stranger, and who's then taken to, in some circumstances, to live with people that they've never met before. So the explanation of decision-making to children in the context of legal proceedings is, or as a lawyer, is very different to explanations that must be delivered by the experts in the case. And by that I mean the social workers and the guardians, because the guardians, of course, are trained social workers. So my view is that the child goes through a very difficult time, and the best person to explain decisions generally is the social worker and or the guardian. When it comes to legal matters and explaining legal matters, then of course there are times when my role will diverge from that of the guardians, where the child is perhaps slightly older and has a different view as to what their future should entail. And then it's a case of really directing the information that I'm giving to that child at an age-appropriate level. That can be difficult, and I think some of that comes with experience, and I think being a father of a child of 8, I think that helps as well. In relation to the process itself, as I say, it can, I think, be a very hard process for a child. The processes themselves could do with I think high-level review in relation to when children are removed into care, particularly.
Obviously, you mentioned that the social workers play a big part in explaining decisions and the processes to a child.
Yes.
But we know that there are obviously issues with the recruitment of social workers. So we've had this kind of a revolving door in the service. The legal proceedings may be lengthy. So how can you ensure that the child is well surrounded when the social worker that might be at the outset of the case has maybe changed maybe 2 or 3 times over the course of the proceedings?
And I think you've asked me a question that hits on a very topical point, insofar as, first of all, I want to say that social workers that I've been involved with and worked with, there are many good social workers out there. And in my view, all of the social workers really want to achieve what's best for the child. There's no doubt about that. But I think the turnover of staff in the children's service is a real problem, and it's been a problem for some years. And I think in my experience, I've seen the change in directorship, senior management, and many social workers on the ground. And the problem with that it really flows in 2 different ways. One is that you don't have, in my opinion, the structure at management level and the support and guidance for social workers that they really require. So that's one point. From the child's perspective, you're quite right. I've been involved in cases where a social worker will change very quickly, and where there can be more than 1 or 2 or 3 or 4 social workers. There might, in fact, be as many as 5 social workers in a child's life throughout the course of the care proceedings. To some extent, that's, I suppose, out of the hands of the Children's Service. But it would be better, I think, if there was more stability in the management structure, then I think that would surely have a knock-on effect, that it would give better guidance to social workers. And I know some social workers become disillusioned in the process because they don't have the support that they need, and they don't have the procedures and the guidance in place and the policies in place that they need to be able to do their jobs
There's been criticism as well of the children's services in the sense that there's obviously a lack of support for the social workers, but there's also a lack of support for the families themselves who need to be able to care after for their children, and they're not given that support. Is that something that you've seen from your side as well?
We must remember that the social worker's role is to focus on the child, and they are the child's social worker, not the parent's social worker. But nevertheless, it's also important to remember that if the family as a whole needs support, and by that I mean the parents and possibly grandparents, or other connected people, if they require support to be able to care for that child, to allow that child to remain in the family unit or with a connected person, then it's very important that support is provided. And I think there are cases where supervision orders are made by the court because I believe that the court feels without an order in place, the children's service will not provide the support that is required by a family. And I think that is unfortunate, because it would be better for a child to be treated as what we call a child in need. That means a child who's not the subject of an order, with appropriate support being put in place for the families at an early stage to avoid the cost and the detrimental experiences to the child and to the family from being brought into care proceedings.
It seems almost there's a very deep problem in the children's service that they're not providing the kind of support that is required, which then causes a higher amount of care proceedings than they probably should need to be.
Well, that's a real possibility. And I only make that observation because when I see cases that come before the court that I'm dealing with, it's unclear to me why there hasn't been a period of assessment during what we would call the pre-action stage, and a period of support, and appropriate support put in place at that stage of the process. Now, don't get me wrong, sometimes the service gets it right. And sometimes they do put in the support and they do avoid the necessity for proceedings. But the problem is there doesn't appear to be continuity throughout the service. And I think that stems from the lack of stability in the directorship, the management structure. That's my view.
I think that ties into the next question I had for you. In the years that you've been involved in children law and that particular area, as the type of cases that you've come across change, have the kind of recurring themes changed over the years?
Not really. It's often neglect caused to children by possibly the parents being alcohol dependent, or a parent being a drug user, or domestic violence in the home. Or in fact sexual harm in the home. So the themes of dealing with children or assisting children remain pretty much as they are in the UK, save that you don't have the gang-related issues that impact on children that you do get in the inner cities in the UK. But no, the themes are generally the same, and they revolve around the type of neglect and the type of emotional harm that flows from alcohol, drug misuse and domestic violence predominantly.
It recently emerged that all of but one child sent to Greenfields over the last 5 years had been in the care of the children's minister. Do you think that this shows the current system is not working and not achieving the best outcomes for children? Or do you think it's maybe linked to the lack of therapeutic care in the island?
I think it's both, to be frank. I think that Greenfields is being used in a way that really it shouldn't be. So I think earlier intervention, I'm quite sure, would result in less children requiring secure accommodation in Greenfields. So my view is, in my experience, that if there's earlier intervention and correct intervention, then it might put the family, and in particular the child, on a different trajectory, which would hopefully avoid that child then being placed in secure accommodation. I think also where you have a child who has been the subject of significant harm and needs therapeutic intervention, unfortunately there's nowhere for that child in Jersey, and it's been a long-standing issue before the court that type of unit is required in Jersey. We really need a therapeutic unit. And without that, it means that Greenfields is in some cases being used as a short-term solution for children who have significant psychological difficulties. So children who are, for example, self-harming due to psychological issues that they suffer and who are putting themselves at risk because there's nowhere else. And that's a real shame because Greenfields is not a therapeutic unit. And I want to say that the staff at Greenfields are fantastic. They are really caring staff. I've met most of them. And the unit is run very well by people who mean well. But you must remember that it's secure accommodation, which means that you have a door that is akin to a door in a prison. You have rooms that are like cells. And the purpose of those rooms is to make sure that the child won't harm themselves, of course. So you end up with a room that very much looks like a prison cell. You walk in, the door is a thick cast iron door with a little portal in it so that one can look through and check on the child. And for example, the sink is fitted into the wall to make sure that it can't be, I suppose, torn from the wall or the child can't damage themselves on the sink. Well, it's accommodation that is not suitable for a child who requires therapeutic intervention.
Whenever the creation of a new unit or a new facility is discussed in the island, it always goes back to the kind of resourcing issues and maybe whether there is actually a need for it. But with the number of care proceedings that we see going through the court, there seems that to be a need. Would you agree with that?
There absolutely is a need. And any childcare practitioner you speak to will, I think, agree with that. And I think if you speak to the Children's Service at the highest levels, if you spoke to Mark Owers himself, I think he would agree, yes, there is a need. And it's a shame that therapeutic unit hasn't yet been set up. And I don't really understand what the hold-up is. In particular, when I see how quickly Hope House was established, with all the resources that it had, I just cannot understand why the Children's Service cannot do that. The same thing within a reasonable time frame. Now, I appreciate that Hope House was a very specific unit for short-term treatment and that setting up a therapeutic unit is slightly different. Nevertheless, when we are told that, well, we don't have the accommodation, we don't have the property, or we don't have the correct regulation, that concerns me greatly. And I find myself asking, well, we have many properties, for example, around the old St Saviour's Hospital. Why can't a property be allocated for this purpose? Why can't the government work together in the best interests of children to make sure that the property is correctly regulated? Why can't therapists be acquired and brought into the island to work with children as they were in Hope House? And I don't, of course, know why Hope House was sidelined by the government. I can only speculate. But I think it must be of some embarrassment to the government that unit was set up so quickly with everything a child needed for that type of support, short-term support, and that the government still seem unable to achieve this.
You mentioned in your previous answer that early intervention was really important. What do you think about the length of time between, for example, a concern being raised about a child that's potentially suffering either emotional harm or abuse at home and actually action being taken?
I've come across many cases where children have been left in a very damaging environment and have been caused harm by that. And of course, I have a number of cases that I can't talk about, which I'm dealing with, where you have adults who have suffered as children tremendously as a result of being in care and the care not being appropriate, or through failure of early intervention. Now, as I see it, the problem, or part of the problem, is that in some cases the Children's Service acts very quickly and don't really have a basis upon which to act. In other cases, they act quickly and they get it right. Unfortunately, in other cases, they just don't act quickly enough. And there's no continuity, as I see it, in relation to the cases that I see both in pre-action proceedings and before the court. And I think that it very much depends on the social worker who is making the decisions. And this, I think, again, must relate in some way to the failure to have policies and processes in place that support the social worker on the ground, I think.
Are there any cases where maybe what either the minister or the services are asking for is something that legally cannot be done or is breaching a child's human rights? Or
there are actions taken generally before court proceedings are commenced where the human rights of children and families and parents are being breached. Once the case is before the court is very aware of the landmark European cases which are relevant to the human rights of the child and the parents. Now, of course, there's case law that says the human rights of the child must prevail where there's a balancing act to be conducted. But in my experience, the court conducts that balancing act very well. So once the proceedings are before the court, no, I don't think the human rights of the child and the parents are breached as a result of decisions made by the court. I think our judges are very alive to the human rights issues. So I think breaches generally come from the children's service not doing what they should be doing or doing it in an incorrect manner before proceedings are issued.
So what is one change that you think we could make today to make the process friendlier to children and to improve outcomes for them?
I think it goes back to my point on early intervention. Early intervention at a pre-action stage. So when the service becomes aware of a family that is struggling because of a problem in the household, which might be domestic violence, which might be alcohol misuse or drugs misuse, then I think it's important they engage the family at an early stage. And that's much better for the child because, of course, if the family can be engaged at an early stage and the appropriate support can be provided to that family. And it won't always be possible. There will be cases which will end up before the court because the family just can't do it, because a parent just can't stop taking drugs or can't stop drinking. But early intervention would make it so much more child-friendly and would avoid situations where children are removed from care at very short notice. And that I think, is extremely harmful for children. And I've been involved in cases where I've seen some horrendous situations that have resulted from that very quick removal into care, where the child has become accustomed to, if you like, the emotional and physical harm that they've suffered in the household, doesn't have any idea that they could be taken away from that household, and then is taken away from their family very quickly. So I think early intervention is the key. The other change that I think would be most helpful is for there to be good legal support for the children's service and the social workers. And by that I mean training that is delivered to the service, and specifically to the social workers on the ground, which explains how they should be exercising their powers in accordance with European law. And I make that point because whilst I was at the Law Officers Department, I don't think that there was ever any training delivered by the children's team, now known as the safeguarding team. And I think that's really important because only a lawyer will be able to explain to the social worker how the development of law within a particular area impacts on what they should be doing. So I think that's a change that could really benefit the children's service.
Thanks to Darry Robinson for talking with me today, and thank you for listening to the Bailiwick Podcast. You can find more episodes on all the pod places, and don't forget to like and share it. The music you hear is I Shift My Weight by Juno. More on the Bailiwick Podcast next week.